So welcome, ladies and gentlemen, and thank you very much for joining the Indonesia Leading Edge. Today's topic is about Omnibus and Omnibus Law, the job creation regulation that is implemented by Indonesian government. Specifically today, we'll cover the employment regulation. And before we start the event, allow me to introduce myself. I'm from the Indonesia Chamber of Commerce in Hong Kong, short for Inacham Hong Kong. I'm the vice president, and I'm grateful to host this event with Inacham China, as well as Inacham Macau. So that's right, if you are interested to do business in Indonesia or with Indonesia, and you're located either in mainland China, in Macau, or in Hong Kong, we hope you can join us and join our community of entrepreneurs and business owners so that we can grow our business together. If you're interested, please feel free to contact us and visit our website, which is www.InachamHK.com. So InachamHK.com. I don't know whether you guys can see in the background. Maybe I'll post it in the chat box later. One more note, if you're actually in Indonesia and you would like to get in touch with us, we don't have a branch in Indonesia, but we have an affiliate, which is Indonesian Hong Kong Business Association. And we want to thank them for supporting the organization as well. And of course, we couldn't have done this without our partners. A special thanks for the support of Indonesian Consulate in Hong Kong and Macau. And Consul General Mr. Ricky Suhandar will be doing an opening speech for our topic. Last but not least, the star of this webinar today, who will be delivering the most important topic, the most important content for us, from HHP Law Firm, a member of Baker McKenzie Law Firm around the world. I think their professionality, later on, you guys will see the depth of knowledge speaks for itself. All right, enough from me. So let's welcome Mr. Consul General Ricky Suhandar for the opening speech. The floor is yours. Thank you.
Thank you, Pak Brian Chan, for kind introduction to me. Pak Brian, Vice President of Inacham Hong Kong, Pak Joni, Vice President of Inacham Macau, Ibu Venda, the General Manager of Mandiri Hong Kong, and Indonesian Ambassador to Kuwait, His Excellency Bapak Tritariat. Thank you, Pak, for joining us in our today's webinar. And prominent speakers from Baker and McKenzie, Hadi Putranto, Hadinoto Partners Law Office, distinguished participant, ladies and gentlemen. It is a great pleasure for me to participate in these important topics. So allow me to extend my gratitude and appreciation to Indonesia Chamber of Commerce in Hong Kong, as well as HHP Law Office in arranging today's webinar. This is a great opportunity for us to continue to strengthen our partnership and hopefully boost Indonesia and Hong Kong bilateral relations. If may I recall, I have no doubt to highly value the role of Inacham Hong Kong in strengthening economic cooperation between Indonesia and Hong Kong. Since 2017, if I'm not mistaken, Indonesian Consulate has been working together with Inacham in promoting economic relations and bilateral trade between Indonesia and Hong Kong. So distinguished participant, it has been difficult for us to navigate through the situation that none of us have really anticipated nor experienced in our lifetime. Global investment and trade has been disrupted, with global supply chains being delayed and industries in most countries being suspended to contain the spread of COVID-19. Investment growth also declined with the rise of uncertainty. So in this connection, Indonesia realizes that having strategic and comprehensive partnership with its partner nation would also entail by necessity to upgrade its capacity to live up the spirit of partnership. As part of the efforts, government of Indonesia aims to improve Indonesia investment climate, create more job opportunities for Indonesians, as well as enhance Indonesian small, medium enterprises and private sector's collaboration. So for that purpose, President Jokowi has signed the job creation law. The Indonesian government hopes that ratification of job creation law is able to deliver positive messages for both domestic and foreign investors and accelerate direct investment realization in Indonesia. Having discussed about trade, investment, and job creation law, the most pertinent questions would be how the job creation law relates directly to foreign investment context. I think the answer is simple. The job creation law is not merely a law on job creating. It is in effect a groundbreaking law that supersedes no less than 77 existing law and regulation. Later on, our colleague from HHP will elaborate more about this regulation. And the third is effectively ends the previously cumbersome regulatory framework into a simple yet robust one. So it is aimed to create a robust and effective economy. Or in other words, the job creation law creates a converging momentum beneficial for both Indonesia and investors and deserves support of the international community. Ambitious in strengthening rather than weakening the response of Indonesia to economic and social issues. So distinguished participant and Pak Brian, to end my remarks, I would like once again to wish my utmost appreciation to InachamHK and Baker McKenzie Law Office in its role to fortify our cooperation and also to encourage Hong Kong businesses to increase engagement with Indonesia. I'm confident today's webinar will clear doubt and concerns being expressed by many regarding this particular law. And the government of Indonesia welcome constructive views of our foreign investor and trading partners alike. And I hope our today's webinar also can give us enlightenment about the creation of Omnibus Law. So I thank you once again, Pak Brian and participant. Thank you very much.
So HHP will now take over the presentation, and let's welcome our first speaker.
Thank you. Thank you, Pak Brian and Inacham Hong Kong for giving us the opportunity to collaborate with you today to host a joint event where we will go through the employment sector today. Thank you also to Pak Ricky Suendar for providing us a background about the Omnibus Law earlier. I would also like to thank you to all participants for your time to join our events today. Allow me to introduce myself. My name is Helmi Handoko. I am the Senior Business Development and Marketing Communication Manager at HHP Law Firm. Before I introduce you to our speakers today, allow me to go over a few housekeeping notes. The first one, the session is being recorded and the slides of today's webinar will be provided in a follow-up communication to you. Please use the Q&A button at the bottom of your screen to submit your questions at any point of today's session. We will be addressing these questions at the end of the presentations, and we will do our best to get to all of them. Lastly, similar to most of you, we are all working and presenting from our homes. Thus, we attempt to create a studio-like atmosphere for this session, but however, please forgive the occasional background noise. Without further ado, I would like to introduce our speakers today. The first one is Ibu Alfira Wahyu Sudibyo. The second one is Bapak Rinaldo Aditya, and the last one, but not least, is Ibu Yesi Samosir. I'll hand it to Ibu Alfira to start the session for today.
Thank you very much, Helmi, and thank you everyone for participating in today's session. Special thanks to Inacham as well for helping organize this, and also to Pak Riki especially for giving the opening speech, the keynote speech. It is well appreciated. And in line with Pak Riki's earlier opening remarks, the job creation law is basically intended to boost investments in Indonesia. So in the hopes of improving all the economies and creating more work opportunities for everyone, especially in Indonesia. In that respect, the proper name of the law is actually job creation law, but it is more popular mentioned as Omnibus Law. So we are just going to use the popular terminology, Omnibus Law, because it is popular. Okay, so if we can move to the next slide, please. So the agenda that is for today, we will try to cover all these 4 aspects. We are focusing on the implementing regulations of the Omnibus Law, which are related to the employment matters. So just on the employment aspects. There are already quite a number of implementing regulations of the Omnibus Law that have been issued. And then there are several are actually related to employment. But for today, we'll focus on the definite period employment agreements or fixed term contracts. Some of you might call it that. The employment of foreigners, which we'll touch very briefly on visas and work permit requirement. And of course, termination of employment, which is quite a popular topic for Indonesia, given we are quite special in terms of how termination is to be conducted legally in Indonesia. Now with that, let's look at the implementing regulations in the next slide after this one. Yeah. So there are actually already 5 government regulations issued that relates to employment as well as immigration. The immigration aspect of course, obviously relate to foreigners working in Indonesia. So the work permit, the visas for working in Indonesia, the stay permits and things like that. The other regulations is, if you see there, Regulation 34 is mainly regulating the work permit itself. So if you are familiar with the terminology RPTKA, that's something that is addressed in Regulation 34. For today, we'll focus on just 3 regulations, which are very relevant to what we are the topics that we're talking about today. So that's the Regulation 34 and Regulation 48. 48 is about immigration, and of course Regulation 35, which covers the definite period employment agreement and termination of employment. Other than also addressing outsourcing, working hours, and overtime. Now, with that, we'll go into our next slide. Just to give a very high-level summary, in relation to definite period employment agreements, PKWT, basically the requirement that that the employees employed under PKWT or definite period employment agreement needs to be something that is temporary in nature, not something that is permanent in nature, is still there. It's just that what the government regulation now introduced is actually a possibility for a longer contract period. And also there's the introduction of a new obligation for paying the compensation pay or uang kompensasi, which is applicable upon contract expiry or the early termination of a contract. We'll get into these details as we go delve further during this session. In terms of visas and work permits, the types of visa generally are still basically the same. There's the single entry visit visa, there's the multiple entry visit visa. But then again, pre-investment activities is actually now clearly referred as an activity in Indonesia that foreigners can obtain single or multiple entry visit visa for. Generally, it's a longer maximum stay period for single and multiple entry visit visa. And then directors and commissioners who are shareholders of companies are basically exempt from work permit requirement. Just on this, the regulation relating to utilization of foreign workers, Regulation 34, it was issued, the date of its issue was the 2nd of February, if I'm not mistaken. But then again, it does have a sort of like a grace period, so that the provisions of these Regulation 34 will only be effective on 1st April 2021. And mainly this is to accommodate further implementing regulations to be issued by the Minister of Employment, essentially. Because there will be some slight changes, not very significant, but slight changes as to procedural matters. Now, for termination of employment, Indonesia has been quite known, if I may say, as a jurisdiction that very much protects employees. It's quite difficult to terminate employees unless it is a mutual termination. So now what's changed is that there's an additional procedure where employers are required to serve 14-day notice of termination to employees or union if there's a union. This is something new that was never, notice of termination is not really a recognized terminology previously in the Indonesian labor laws and regulations. And of course, there is the lower termination payment for indefinite period employees. Previously, the maximum would be around 32.2 months salary, the absolute maximum, but now it's down to 28 months salary and only in certain circumstances. Now with this, let's look into the definite period employment agreements topic. And I believe Yesi will be speaking on that. So perhaps next 2 slides.
Thank you, Mavira. Good afternoon, everyone. So on definite period employment, so definite period employment is actually one of the key changes to the labor law brought by the Omnibus Law. Now, the implementation of definite period employment is now further regulated under Regulation 35. So Regulation 35 essentially sets out requirements on definite period employment agreement, including the type of work and contract period, depending on the type of definite period employment agreement. So there are 3 types of definite period employment agreement, which is employment agreement that is based on period of time, based on completion of certain work, and for other work that is not permanent in nature or daily workers. Now, in terms of type of works, for definite period based on period of time, the type of work that can be agreed here is work that that the completion, which completion is not too long, and seasonal work, and also work that is related to new products, new activities, or additional products that are still in trial or experiment. Whilst for definite period employment agreement based on completion of certain work, the type of work is those work that is can be completed one time, and then temporary work. Now, in terms of daily workers, the type of work is any work which period and volume keep changing, and the payment for the worker is based on attendance at work. Now, Regulation 35 also specifically provides the contract period for definite period employment agreement, again, based on the types of agreement. For definite period employment agreement based on period of time, the maximum contract period is 5 years. This 5 years period includes the extension. So you can extend the initial contract, but the total contract period for all contracts is maximum 5 years. For definite period employment agreement based on completion of certain work, the employment agreement must include the scope and limit, must also include the period of work completion. So the period required to complete the work. It is possible to extend the contract period if by the time the contract expires, the work itself has not been completed. For daily workers, the contract period, the maximum contract period is 20 days in a month. We should also note that if the employee is working for 21 days or more for 3 consecutive months, then the employee could be deemed as a permanent employee or indefinite period employee. Regulation 35 also still requires registration. So, but now the Regulation 35 introduced new online registration, which needs to be conducted 3 working days from the date of signing of the employment agreement. Regulation 35 also mentioned that if the online registration system is not yet available, then the employer can do the registration manually at the local employment office at the latest 7 working days from the date of signing. Next slide, please. Now, the other important provision under Regulation 35 is the requirement to pay compensation pay. Basically, this requirement is a newly introduced obligation, employer's obligation under the Omnibus Law and also under Regulation 35. So basically, employers are now required to pay compensation to definite period employee upon the termination of the employment. Now, as you can see in the slide here, there is a formula to calculate the compensation pay. Essentially, the compensation pay is calculated based on the contract period of the definite period employee. What we should note also is that this compensation, foreign workers, non-Indonesian definite period workers are not entitled for the compensation pay. And then this compensation pay must be paid at the expiry of contract and at each extension of contract. Now, on the calculation of the compensation pay, the main point here also is that the compensation pay is calculated based on the actual period of work. So basically, if the work completed before the agreed term of the employment agreement, then the compensation pay is calculated based on the from the commencement date of employment until the actual completion date of the work. It's also the same also applies for early termination of definite period employment. So basically, if the employment is terminated before the expiry of the contract, then the compensation pay is calculated based on the period of work that has been concluded by the employee. One last point on the compensation pay is that if currently there is an ongoing definite period employment agreements, then the compensation pay, the calculation of the compensation pay is calculated as of 2 November 2020, which is the date of the issuance of the Omnibus Law. So it's not calculated from the start date of the contract. I think that's all on the key in the highlights of the definite period employment. I'm going to hand this over to Rinaldo to explain on the next topic.
Yeah, so yes, just before we go to Rinaldo, a few things that I would like to add on this is that we also need to bear in mind that if you can go back one slide, is the type of definite period employment agreement, because this will will help determine the contract period that is permitted for the definite period employment agreement. If we have like a project and we know the project will the project period, how long the project will take, then perhaps consider using definite period employment agreement based on completion of certain work, because then you will be able to determine the scope and limit of when you declare the project completed, and also the expected period for the project. And in case the project is not completed by the time you expected the project to be completed, you can still extend the contract as needed. And the payment, the compensation pay, will be calculated, based on when the project actually complete, because that's actually when the definite period employment that is based on completion of certain work actually ends. So on that, let's go to Rinaldo, who will guide us through the relevant regulations, government regulations related to foreigners working in Indonesia. So over to you, Rinaldo.
Okay, thank you, Mbak Alvira. Good afternoon, everyone. So I think on these occasions, I will basically convey about the changes that brought by the Omnibus Law and the implementing regulations on the expatriate employment sector. Actually, this is also one of the sectors that the government would like to improve to basically to make it easier for foreigners, especially foreign investors, to come to Indonesia and conducting business in Indonesia. And I think as mentioned by Ibu Alvira in the beginning of the presentations, basically there are two main regulations that sets out these topics, which is the first one is the GR34 about the utilization of foreign workers. And the second one is GR48. This is actually an amendment to the existing government regulation, which sets out about immigration matters. I will start by I think telling the highlights of the regulation 48 first. It's mainly related to the immigration permits that is needed by foreigners to come to Indonesia for certain purposes. In this case, this regulation was issued on 2 February 2021 and immediately in effect on the date of the issuance. If we are talking about what is significant changes that is brought by this regulation, the first one is about single entry visit visa and multiple entry visit visa. we normally call it as a business visa, as basically the main purpose of these visas is for any foreigners come to Indonesia for conducting business. It can include conducting meeting with any subsidiary in Indonesia or business partners and etc. But it is not for working. Basically, all the permitted activities under the single entry visit visa and the multiple entry visit visa are still the same, but the government has included new additional activities for these visas, which is pre-investment activities, as mentioned in the beginning. It includes conducting field survey and or feasibility study. There is not so much remarks on or definitions about these activities, so it can be interpreted broadly by both the government authorities and the employer or business conductor itself. The second one is if we are talking about the changes, is now the single entry visit visa, the validity period of the single entry visit visa has been extended. Previously, it valids for maximum 60 days, but now the government has decided to extend the validity period to become 180 days. But in this case, there is no extension permitted to the single entry visit visa. And the second one, the multiple entry visit visa, it would also be the same in terms of the validity period. The government has decided to extend the validity period to become 180 days per entry. Extension is permitted for this multiple entry visit visa, but the total stay cannot be more than 12 months. I think that the next changes that is brought by this regulation is also on the validity period of the limited stay visa or VITAS. As you may be aware, in Indonesia, if any foreigners want to come to Indonesia for working, the working visa is called as limited stay visa. Now this is valid for 180 days. This VITAS, we call it VITAS, is actually needed for foreigners to come to Indonesia and to process the next permit that will be required to work and stay in Indonesia, which is, we call it a stay permit or ITAS. The next changes that is brought by this regulation is previously there is a limited stay visa or VITAS that is basically set out activities for elderly foreign tourists to come to Indonesia. But now this reference to elderly foreign tourists has been deleted. Instead, the government has included a second home as one of the scopes that can be covered by a VITAS. Actually, from the elucidations of the government regulation itself, second home is actually an immigration facility that is given to foreigners and or their family that will stay in Indonesia, that has stayed in Indonesia for 5 years or 10 years after has been fulfilled certain requirements. But unfortunately, this government regulation has not described what is the requirements for the foreigners to obtain this second home VITAS. We expect that such requirements will be further set out in the implementing regulations of this government regulations, which is will be set out in a ministry regulations level. For the visa on arrival, the maximum period of stay will be 30 days, and there is also no extension in this case. For the limited stay permit or ITAS, which is required for foreigners to work and stay in Indonesia, the maximum validity period is 5 years. Previously, actually, the maximum period is only 2 years. Extension is permitted, but the total validity period cannot be more than 10 years. So there is also actually an improvement on this matter, because previously the total validity period cannot be more than 6 years, now become 10 years. Yeah, I think that's the main highlights of Regulation 48 we can move to the next slides. Okay, the next one is the second government regulation, which is the regulation 34, which focus on the utilization of foreign workers. Just for a starting point, this was issued on 2 February 2021, but this will become effective as of 1 April 2021. So now this has not yet become effective, but I think in the next around 3 weeks, then this regulation 34 and all the provisions will become valid. So not so long time up until that date. In this regulation 34, the principle will still be the same. Foreign worker can only be employed by certain positions. And then foreign workers still cannot hold positions managing personnel. It's related actually with any matters that is related to human resources. So the positions will still be the same. If we are talking about the employer's obligations, in this case, there are not so many changes on this in terms of the obligations of the employer. Employer will still need to obtain or apply for a foreign manpower utilization plan, or we call it RPTKA. This is actually proposing as a permit to employ a foreigner now, to employ a foreigner to work in Indonesia. The next one, the employer will need to appoint an Indonesian counterpart worker for the purpose of a transfer of knowledge and technology. It actually has been implemented before the issuance of the Omnibus Law and the government regulations. There is also still the obligations for the employer to implement job education and training for that counterpart worker and facilitate Indonesian language education and training for the foreign worker. Of course, there are certain exceptions for these obligations, the 3 obligations related to counterpart worker. The first one is if the individual, the foreigner, will be appointed as a director or commissioner of a company, a chief representative of a representative office, and for foundations, if the foreigner will be actually appointed as a founder, administrators, and supervisor of foundations. These obligations are also not applicable for temporary work, which will be described in the next slides. Basically, for certain temporary works, there is no obligations for the company to comply with the counterpart requirements. The next topic, which will be dual positions. Previously, the dual position are very limited in terms of what position that can be held by foreigners in multiple companies. The default is foreigners cannot having multiple positions, but there are certain exceptions. Under the regulation 34, the dual positions can only be implemented if the foreigner is a director or a commissioner of the companies. For example, there are certain group companies, and you would like to appoint the foreigners in company A and company B, then it is possible. The second exception is if the foreigner is holding certain titles in certain business sectors, which is defined as a vocational education and training, digital economy, and oil and gas. The main requirements for having a foreigner with dual positions in certain companies in Indonesia is the first employer, the first company that appoint the foreigner must agree. The second one is all the employers will employ the foreigners will need to obtain their own RPTK approval. So there will be more than one RPTK, depends on how many companies that will employ this foreigner. The RPTK approval under the second or third employers, etc., basically will valid until expiry of the first RPTK. So it actually, I mean, we can say that all the RPTKs will be linked and will follow the first RPTK. It will not be possible for the second, third, and etc. RPTK approval will have a different validity period. The regulation 34 actually will actually refers to certain topics will be further implemented by a ministry regulations level. This includes positions open for foreign workers, titles in certain business sectors that are permitted for dual position, and then positions that are managing personnel and are closed or prohibited for foreign workers, including the application procedure for RPTK approval, extensions, and amendment of payment of the DKPTKA or fee for utilization of foreign workers, the work, educations, and training for Indonesian counterpart worker, and a procedure for imposing administrative sanctions. Just want to basically let you know or remind of certain matters. Actually, there are certain existing Ministry of Employment regulation that set out the matters that I just mentioned, which one of them is the position of foreign workers and what positions that are prohibited for foreigners. In this case, as long as these regulations, these implementing regulations are not inconsistent with the regulation 34, they are still valid. The next slide, please. Okay, the next one is as mentioned, RPTK is the permit to employ foreigner. As you may be aware, previously up until now, actually, as basically regulation 34 has not yet become effective. Currently, the process for obtaining a work permit for foreigner is started by applying for RPTK. The next one, once the RPTK has been issued, then the company or employers will need to apply for a notifications. After that, they will apply for, the company will apply for FITAS and also the stay permit or ITAS. The regulation 34 basically has simplified the process for work permit applications for foreigners. Now by the effective of the regulation 34, there will be no longer notifications to be applied for the foreigners to work in Indonesia. So there will be only an RPTKA to be applied by the company. And the next ones, we can jump to the next step, which would be applying for the FITAS or limited stay visa, which will be described in the generally, the RPTKA will valid for a maximum 2 years and it can be extended, except for certain types of RPTKA, which is RPTKA for temporary work. It will valid for only 6 months. There is no extensions. The RPTKA for temporary works is actually will be put in place, will need to be put in place for certain temporary work only, which will be described later. It includes, for example, the foreign company would like to do certain inspections, come to Indonesia. The other exception is RPTKA for special economic zone, which is valid 5 years and it can be extended. The regulation 34 also provides certain exemptions for employers for not having RPTKA, which is directors or commissioners with certain share ownership or shareholders, as mentioned at the beginning of the conversations, and then a diplomatic and consular staff at foreign countries representative office. And the third one is if the foreigner is required in productions activity that have stopped due to an emergency, vocational, educational, and training, technology-based startups, business visit, and scientific research for a certain period of time. I think for the first exemption, which is the directors or commissioners with certain share ownership or shareholders, is quite interesting, and many our clients asking, is there any limitations on, for example, certain share ownership or shareholders, we can say that actually the regulation 34 does not specify or put certain limit of the share ownership or shareholders. It might be further set out in certain ministry regulations, but up until now, it remains to be seen how it is being implemented, whether it can valid for any directors, or even if they only, for example, hold 1 shares or 1% of shares. I think that the next point will be tech-based startup and vocational education and training. The exemptions from RPTK approval for this business basically limited to a maximum 3 months period only. And then the regulation 34 requires employer to submit data of the candidate to the Ministry of Employment. So it is still required even though you will not apply for such RPTKA. Job titles in the tech-based startups and vocations will be further set out in the Ministry of Employment. So up until now, it's still not clear which titles that can be included under this scope. The next slide. The regulation 34 basically also sets out certain reporting obligations to the Ministry of Employment. For the first report, actually the annual report, the employer will need to report the utilizations of foreign worker, education and training for the Indonesian counterpart worker. In addition, the employer also must report the transfer of technology and expertise from the foreign worker to the Indonesian counterpart worker. The regulation 34 actually are not specifically describes about the technical process for doing the reporting requirements, and we expect that it will be further set out in the ministry regulations of the Ministry of Employment. In addition, for temporary work, the employer is also required to report the utilizations of foreign worker upon expiry of the employment agreement. Employer also is required to report any expiry or early terminations of foreigners. Meaning, if you would like to terminate the foreigners before the expirations of the employment agreement, then employers will need to submit certain report. Again, the regulation 34 does not specifically set out the technical process on this. So it remains to be seen how this reporting requirement will be implemented in the futures, and we expect and we hope that it will be clearly set out further in the Ministry of Employment regulations. The next slide, please. Well, this is actually the chart for the work permit application process under the GR34, which will become effective in early April, as mentioned. If we can see, the first step is to submit an RPTK applications. There will be certain assessments on the eligibility of RPTK applications that will be conducted by the government or the authority. We are actually also curious about this process because I mean these regulations does not clearly set out whether there is a whether this assessment result will be issued in certain product and it will be issued to the employer, for example, as like pre-approvals, or whether actually this assessment will be conducted only for the purpose of internal assessments by the authorities to approve on the RPTKA. As the next step is still in the RPTK application process, there will be submissions of foreign workers data after the assessment. Once of course the assessments has been issued by the authority, the government will issue a billing code for the KPTKA payment, which is the fee for the foreign worker utilizations. As you may be aware, the DKPTKA billing code was normally issued after the approval on the RPTKA has been issued, but now it is issued and needs to be paid by the employers before the issuance of the RPTKA approval. So to make sure that the employer will obtain the approval of the RPTKA, then they will need to first pay the DKPTKA payment. The next step, the government will issue the RPTKA approval. Once the RPTKA approval has been issued, then there is no applications of notification process, which still actually going up until now, as this regulation has not yet become effective. Instead, the company can start go to the next process, which is to apply for the limited stay visa or VITAS for the foreigners. After the VITAS has been issued by the immigration authority, then the company can apply. I mean, the foreigner can come to Indonesia with that VITAS and can get their ITAS in Indonesia. I think that's the general work permit application process. There is a certain simplifications of the process on these matters. The next slide, please.
Okay, the next slide is actually my part. We'll go over on termination of employment.
Yeah.
I'm not sure who has the control and can switch from Ronaldo's to me as the spotlight for the spotlight. Okay, for termination of employment in Indonesia, as I mentioned earlier, there is a new concept, which is termination notice. This is something new. Before in Indonesia, if we're talking about termination of employment, the initial step is basically to speak to the employee or the union if there's a union, and basically commence with bipartite negotiation. So it's always a mutual termination that is the main intention for terminating employment relationship in Indonesia. There's no specific requirement on termination notice, which is basically like in other jurisdictions, is like a notice to the employee, typically in writing, where the employer basically say to the employee that you will be terminated as of X date, as of a particular date. That is not the case in Indonesia previously. Previously, it's, yes, the employees will need to be spoken to. So there should be some sort of communication started. And that is actually the intention through bipartite negotiation, as in the chart you will see there, that is that are the dark blue boxes. If employer wanted to notify employees about a proposed termination, previously the termination notice is simply for essentially asking the employees to come and sit together with the employer to basically discuss about the termination and come to an agreement on when the termination will be effective, as well as the payment that the employer will pay to the employee. Now with the termination notice, it's more a concept adopted from several other jurisdictions, where the employer will basically send a letter to the employee or the union, if there is a union, 14 days before the intended effective date of termination. In that termination notice, the employer will need to specify what the reason for termination is, as well as the payment that the employee will receive for the termination. The employee or the union, once they receive the notice, the termination notice, they have 7 working days to basically object to the termination. And the way to do this is by basically responding or writing a letter to the employer saying that they don't agree with the termination as proposed in the termination notice. If the employee or the union does not agree with the termination and have sent the written objection, the next step is to go into the bipartite negotiation. So it's this basically is the usual or the formal termination process, or even the employment dispute resolution process under the Industrial Relations Dispute Law, Law number 2 of 2004. If after the issuance of the termination notice, the employee or the union does not they don't send any written objection to the employer, then essentially the termination should be effective as per the termination notice. There is a requirement for the employer to report to the Ministry of Employment or the local office of employment about the termination notice. This is also something new because previously, if the employer and employee agree on the termination, meaning a mutual termination is reached, then there should be like a mutual termination entered into and signed by the employer and the employee. That mutual agreement needs to be registered at the Industrial Relations Court where it is signed. So there was no involvement with the documentation with the Ministry of Employment or local office previously, unless we are going from bipartite negotiation to further dispute settlement procedure in the local employment office, which is for mediation or conciliation. Another important, what is important from this is that this would seem to try to ease the process of termination of employment for employers, essentially, because all it takes is basically just a written termination notice. Of course, there is there would still be risk if the employee union does not agree on the termination, but that is then when the parties will need to initiate the dispute resolution procedure. One key exemption for termination notice requirement is if the termination is for urgent reason. The government regulation 35 actually now recognizes termination for urgent reason. It is basically where the violation, misconduct of employee is so severe that it's basically not a very good approach if still serving employees warning letters, because then warning letters are basically to help correct mistakes or help improve on performances. But this is something that's in practice before Regulation 35 has been adopted in practice, but it wasn't specifically regulated in any in the Indonesian labor law number 13 itself or in various minister regulations and decrees. So it is basically adopting the practice. Now, if we go to the next slide, the next few slides are basically just describing the components of termination payment for indefinite period employees, so for permanent employees. Essentially, it's still the same components. So there are still severance pay, which is essentially 1 month's salary for every completed years of service. And this is also the component which can be doubled. So you probably have heard of 2 times formula, 1 time formula. That formula is basically multiplying the severance pay component by 2 times or 1 time. The second component is in the next slide, please, is the long service pay. This is something that is for 3 years of service minimum, and it's basically capped at 10 months salary. So every 3 years, there's starting with 2 months salary and then increasing 1 month salary for every 3 years of completed services. And then it goes from 8 months to 10 months salary for someone who has 24 years or more of service. The third component is in the next slide, compensation of rights. Is still very similar to the, quite similar to the compensation of rights as provided under the law number 13 on labor. The difference is that in compensation of rights, which is also specified in the job creation law itself, it no longer has the 15% compensation for housing and medical. So that 15% was previously calculated from the total severance pay and long service pay, which are the first two components. But this time, there's no more 15%. And but the compensation of rights is where you have to compensate any earned but unused annual leave that the employee has, travel expenses for the employee to return to the location, original location of hire, if the employee, of course, was assigned to another work location. And if there's anything in the employment agreement, company regulations, or collective labor agreement that that employer needs to provide to employee upon termination of employment, this is also covered actually under the compensation of rights. Another component, which was also already recognized before, is the separation pay, uang pisah. This was for something like employee voluntarily resign or qualified to have resigned because absence without leave. And this is something that employer needs to stipulate in the employment agreement, company regulations, or collective labor agreement. So in a sense, in terms of components of termination payment, there's not much change. It's still the same. They're still basically the same, except for the 15% compensation for housing and medical that's been taken out. Now in the next, I believe 2 slides or so, this is basically the formulas for termination payment. Essentially, as I mentioned earlier in the key highlights, the termination payment formula is decreased, essentially. So the 2 times formula, where it is basically 2 times severance pay, 1 time long service pay, and 1 time compensation of rights, is only for these 2 specific reasons for termination: long-term illness or employee's death. There is the if retirement, meaning the employee reaches retirement age, then it's 1.75 formula. Previously, it was 2 times formula. Then there is 1 time formula for merger, consolidation, separation of company, acquisition, where it's where the termination is initiated by the employer, efficiency to prevent losses, closure not due to company's losses, where the company is in suspension of payment or PKPU, then and it's because of not because of the company's losses, or if it's an employee's self-termination, where the employee basically alleges that the company having having committed certain violations, and the employee's allegation is proven, then the employees would be entitled to 1 time formula. Also, there's this 0.75 formula. This is for force majeure that does not result in the company being closed down. All these are basically less than the formulas that we can see in the previous law number 13 of 2003 on labor. And the next slide also will further see that it's not just up until the 0.75 formula, but in the next slide, please go to the next slide, we'll see that there's still also the 0.5 times formula. This is for acquisition resulting in changes to the terms of employment. An employee doesn't want to continue employment relationship, efficiency due to company's losses, closure because of the company's losses, closure because of force majeure, company in suspension of payment due to losses suffered by the company, bankruptcy of the company, employees violation, etc. So these 0.5 formula, just to give a comparison, a quick comparison. Previously, if it's employees violation of employment agreement, it's the one-time formula. But now it's the 0.5 times formula. The next formula is basically compensation of rights and separation pay. So this is, again, for voluntary resignation. It's essentially pretty much the same, yeah. Voluntary resignation, employees absence without leave for 5 continuous working days, found guilty of a crime by the court, etc. And then there's the long service pay and compensation of rights formula. This is also related to employee criminal offenses. And I believe that's pretty much it for the termination of employment. Essentially, for termination of employment, it is the it is a bit more less stringent requirement than previously, but we'll see again, because this is relatively new and it's a new concept. It's a lot of new concept for Indonesia, actually. So it's going to, we'll see how it is played in reality, in the implementation. But I do hope that this will boost the economy for Indonesia, at least more foreign investment coming in, hopefully. And with that, usually that would entail more job availability for the Indonesians. Now we'll go to let me just guide us through the Q&A. We have a couple questions here, and I think Rinaldo, these questions might be more relevant for you to address. The first question is about what is the maximum and minimum age for foreigners applying working visa quitas. I think before you answer this question, Rinaldo, just a reminder, visa is different than ITAS. Visa is basically, I think our colleagues from the Indonesian embassy and Consulate General are more familiar with this, but visa basically allows the foreigner to enter Indonesia. ITAS allows the foreigner to reside in Indonesia. So Rinaldo, maybe for you, so is there a minimum and maximum age for applying work-related immigration documents?
Well, I think there is no specifically requirements on the minimum and maximum age foreigners applying working visa, ITAS. But I mean, in the practice, as usual, the Ministry of Employment officials may from time to time to impose a certain unwritten policy, which includes the maximum age. For example, for applying a working permit, in this case, the RPTKA, up until the issuance of ITAS. Yeah, I think that that's the answer for this question.
Okay, thank you, Rinaldo. I hope that helps to whoever asked the question. And the next question is basically about the dual position. Should the person either be director only in one company, director in several companies, so it's a director in company A, director in company B, or can the person be director in company A, commissioner in the company B? Is there a maximum number of companies? In terms of the maximum number of companies allowed for one individual, it's not specifically regulated. But then again, it really, this usually depends on the discretion of the Ministry of Employment when they review applications for the work permit for the RPTKA. Obviously, if it's 10 companies, the individual is a director in 10 companies at the same time, that obviously would raise a lot of questions, because then the question is whether the main question would probably be, isn't there anyone else available to hold the director position in other other 5 companies, for example. Whether the company need to have the same shareholder structure is also not specifically regulated. In the past, it has been a policy that the companies that will have the same person as sitting as director or as commissioner should be in the same group. So not necessarily exactly the same shareholder structure, but yes, usually like a chart showing the relationship between the companies, showing that they're somewhat affiliated, basically would have to be submitted, and it's much more easier to obtain the approval for the RPTKA, the work permit, in that situation. But Rinaldo, I think for the question whether the person needs to be either just directors or just commissioners, I think in there's no specific requirement as well. So technically, it's possible that the person could be a director in company A and commissioner in company B. So
that's correct.
Although it's more common for the person to be like director in both companies or multiple companies, not director commissioner in several companies. Okay, the next question is, any ideas on how Indonesia's termination compensation compared to other ASEAN countries? From my understanding, speaking to colleagues in of course, our Baker McKenzie network, Indonesia has always been kind of the top for the most generous termination compensation for employees, especially compared to Singapore and Malaysia, Thailand to a certain extent. Thailand, if my understanding, they had this formula or termination payment calculation required, probably specifically targeted for certain categories of employees, if I'm not mistaken. Singapore and Malaysia, generally, my understanding as well is they have this categorization of employees, determining who will be eligible to what, what. But generally, it's Indonesia is the most expensive. Another question is retired age. What is the retired age for foreign workers in Indonesia holding an ITAS? So Rinaldo, you might want to address this question.
Yeah, I think as mentioned in the material, actually foreigners is employed for certain periods and also for certain positions. So this is not, there is no intentions for an employer to employ foreigners for permanent employees. So I mean, in this case, no retirement age on the employment of expatriate, as it is not relevant. But just to note that, as previously mentioned, the total validity period of limited stay permit, ITAS, is 10 years in total. And I think I want to add my answers to the first questions about the minimum and maximum age foreigners. As I mentioned, it is not regulated expressly, but MOE may from time to time issue certain guidelines or unwritten policies. I think from our previous experiences, the minimum age for applying for the work permit for foreigners is 25, and the maximum age is 55. Hope that's helpful. Yeah.
Okay, thank you, Rinaldo. I think if there's any more questions, I don't see any other questions posted in the Q&A. Yeah, I think just from me, I think a lot of these regulations, especially the Regulation 35, in particular about the termination of employment, this is basically changing the concept in Indonesia with regard to termination of employment. So a lot of this, we are still also learning. And I think I see it as a positive change for the for Indonesia. And I do hope this basically supports the economy, create more, indeed in line with the job creation law itself, will indeed create more jobs for especially more Indonesians, but also make things easier for foreigners to come to Indonesia, work in Indonesia, helping Indonesia's economy as well. Should we? I leave it to to perhaps Helmi and maybe Brian on how we want to proceed on this. If there's no further questions.
So, thank you very much. Thank you for all the speakers from HHP Law Firm. That was a lot of useful information, very dense information. I'm sure it will take a bit of time to digest. And luckily, what we have is we have a recording of this session. So for those who have attended or for those who have signed up, we'll try to distribute some of these material to you so that you can look it over. And of course, as always, if you have any questions, please feel free to contact HHP Law Firm. And as well as if you're in Hong Kong, Macau, or mainland China, we welcome you to join Inacham Hong Kong. We'll put in the chat our contact information, so feel free to join us, contact us for any questions. Once again, I would like to give my most sincere thank you for all the speaker and support from HHP Law Firm as well as Baker McKenzie. Last but not least, I just wanted to give a special thank you to a special guest, Mr. Tri Tayat. He was the previous Consul General from Indonesian Consul General in Hong Kong. Now he's the ambassador in Kuwait. So just wanted to give him a special mention. He has been monumental for the establishment of Inacham. So thank you very much. And we'll pass the floor to Pak Helmi for closing up the event. Thank you very much for everybody's attention, and we'll see you very soon.
All right, thank you very much. Once again, thank you to all the speakers today for your presentation. I would like to also thank Mr. Ricky Suender and Mr. Brian Chen for all your support, and thank you also to all the participants of today's event. This is actually the first session or the first series of Omnibus event that we have arranged with Inacham Hong Kong, and we have prepared other events on other business areas in the next few weeks. So we will be sending over that invitation to you. For more information on HHP Law Firm, please kindly visit our website. It's at hhp.co.id. And also you may find some more informations on our LinkedIn account. Thank you once again, and I wish you all well, and we look forward to see you in our future events. Thank you very much, and have a good afternoon.